Hello there, students of law. Today we're going to be learning about the basics, also known as flow of court. Now, the flow of court is the order of which the court goes in, what comes before what, how the court starts and how it ends. So, the flow of court can go in many different ways. There's, of course, the original, what is most commonly seen by people who are just starting. Of course, you might see it on the screen right now. It first starts with both prosecution doing the opening statement and then the defense. Of course, prosecution always starts the opening statement with the flow of court, and then of course the defense then proceeds, and then of course once that happens, it goes to not witness phase. My apologies. It goes to evidence phase. Evidence phase, of course, proceeds with the prosecution getting their evidence, and then the prosecution proceeding to present their evidence. While that's happening, the defense can object if they see fit. If they see an objection, go for it. If they really wish to hold their objections until last, after all evidence has been presented, that is known as a rebuttal, and will be known as a rebuttal throughout the entirety of court. Of course, after that, that goes the same with the defense. They get their evidence, and then they then present their evidence, as you know, basically. Again, same with prosecution, they can object to evidence that is being presented. And then, of course, once all that happens, if both sides chooses to, or if one side chooses to, then the witnesses come. Of course, the prosecution would get their witness first if they have the first witness. They ask them to come to the stand, After that happens, they would then question our witness. Of course, again, defense may object where they see fit. There's no objecting after on this one. You have to object when you see an objection. Of course, after that, then the opposing party, also known as defense, would cross-examine the witness. Now, what that basically means is they'd approach your stand with permission, then they'd ask some questions related to the case. And then basically, it would just keep going like that until no more questions have been done. Then next, the defense would then bring their witnesses stand. Then, after the defense brought their witnesses stand, they would start proceeding to ask some questions. After the questions have been finished, of course, by the defense, then prosecution would then do the exact same thing as last time, cross-examine, by asking the witness things related to the case. And then altogether would just end up closing statements starting from prosecution defense. Best way to remember it would be opening, evidence, witness, closing, all starting with prosecution. And that's basically the very basics of that one, the most common one. There are basically more ways than one for the flow of court, and this is an example of it. It's known as a withhold tactic. There's two different versions of it. You can either withhold till evidence has been presented from the prosecution, or until witnesses. I'm going to be explaining the evidence one first. So for the evidence, of course, so it first goes prosecution gives their opening statement, then prosecution then proceeds to get their evidence and present it. Once that happens, the defense can object as they see fit. And then, of course, the defense would then give out their opening statement. And then, of course, would give out their evidence. And then it goes prosecution witnesses, and then defense witnesses, and then closing statements from prosecution and closing statements from defense, as you know, basically. And then the final one is as well known as, again, withhold tactic, but this one's until after the witnesses. So it goes prosecution gives out their opening statement, prosecution then gets their evidence, prosecution gets their witnesses, and then the defense starts to give their opening statements, evidence, and witnesses. After all that, of course, it goes closing statement from prosecution, and then closing statement from defense. Of course, that'll be all for today, and that's basically the basics of the flow of court. Thank you.